Pat McFadden tells me he's got to turn the chicken on at 4. So, I don't want to mess up anybody's afternoon meal. Judge Jamie Woods, St. Joseph Superior Court over in Mishawaka. You all know him well. I'm going to stop talking and let him begin.
Thank you, Magistrate Wilson. Just some introductory comments. I know the topic today was, the caption of it is knock it off, aren't you tired of all the fighting? There is contentious. There's no reason to say that these cases cannot be contentious from time to time. I've been on the bench almost 3 years now. I want to say how much respect I have for the family law bar. A few of you I knew before I started practicing law because you delved into the civil world where I got a divorce case put on my desk by somebody that told me to do it. And we bumped into each other, but I have so much respect for the family law bar. You have to be experts in the area of family law and therapy. It's not lost to me. You have to be somewhat knowledgeable of property and benefits and just a whole host of things. It's such to label these as family law attorneys truly doesn't give you justice. Also, I think that the family law attorneys, by and large, are some of the most pragmatic, problem-solving attorneys I've had the opportunity to work with. I know that many of you have appeared in front of me. It's standard practice that if you don't have an agreement, I tell you how I can't draft an order to be near as good as what your clients are going to agree to, and I send you down the hallway, and you try to work it out, and most of the time it gets worked out. So I'm such a big fan of the family law bar, and I know that the attorneys are good for the cases because every time I have a self-represented litigant and it's a challenge and an attorney appears, it's a great day for me. It's like every time an attorney appears, an angel gets its wings in some of these cases. So thank you so much for appearing. I didn't really have a whole lot to add as to knocking it off because I was an attorney for a long time. I've been on the bench near 3 years. I heard the statements that if attorneys would just get their heads together, the cases would settle, or attorneys kept the cases from settling, and that's all just bull butter. The attorneys want the cases to settle. The St. Joseph County Bar, by and large, gets along so well. I've had litigation throughout the state over my law career. Some of the other counties, it's a knife fight from the very start. So I'm well aware of I guess just the luckiness I have to be an attorney or be a judge here in St. Joseph County. But I think there's some things we can take away that might make the process a little bit better, and some things from the local rules I wanted to point out. So let's talk about the first slide. I know John, our Judge Broden, saw this. This is from the greatest baseball movie ever made, Bull Durham. In the famous words of Crash Davis to his young protege, Ebby Calvin LaLouche, after you get to the show, you can let the fungus, after you win 20 games and get to the show, you can let the fungus grow back on your shower shoes and the press will call you colorful. But until you do that, you're a slop. So why did I reference shower shoes? Because we have a dress code here in St. Joseph County in the courts. I know my mind is probably an antique in this regard. I still think there's benefit to advising your clients to show up to court not wearing Crocs, not wearing shower shoes. I would use this term Sunday's best, but I think that's gone out by the wayside too from what I've seen in church. So if your clients know that they need to put on something decent to come down to court and you advise them of that, I think it makes them take the process a whole lot more seriously. That they can't leave the courtroom and go to Costco. And they wouldn't wear the same clothes to Costco as they would to the court. I would never ever hold anything against your client if they do not show up to court in appropriate attire. I probably wouldn't ever say anything to anybody in a divorce case. If you're in a business case or something like that, I might say something to you, or have my bailiff say something to you, as Judge Manier reminded me once, or had her bailiff reminded one of my client representatives that appeared often. There should be no open-toe shoes in her courtroom. And I advised her of that, and there were never any more open-toe shoes. So I think there's a need to take the courtroom seriously. All right. This is from the greatest baseball official or manager umpire argument. This is from Earl Weaver and Bill Howard. This is on YouTube. I think it's from 1980. The Orioles are playing the Angels, and it's the 5th pitch into the game. Howler's brother was an umpire. It's not, if you don't like profanity, don't watch it. But it is the best umpire argument. It goes on for 4 minutes. It is classic on the YouTube machine. Why do I tell you that? Behavior in the courthouse. While in any of the courthouses within St. Joseph County, lawyers, litigants, and spectators shall refrain from unnecessary conversation in the courthouse or in the courtroom that would disturb the proceedings. And I'll add to conversations, gestures, hand waving, raising your hand, things of that nature. I've not seen this so much with the litigants because I think the attorneys can grab them and say, hey, knock it off. I would ask you to please advise spectators that your clients bring, grandparents, others that come to court, advise them of this rule. I've had a couple instances where I've told the attorneys afterward, you know, you need to pay attention to what the people in the back are doing. I thought it was always Judge Manier. When I appeared in front of her in Mishawaka all these years, I thought she had some super hearing up there, but there must be some type of acoustics in that courtroom that funnels everything to that bench, because I hear everything. And I'm not as wise as Judge Manier, but at least I know I'm hearing as well right now. So I hear and see everything. Also advise your clients, is this person really necessary? Is it really necessary to bring the new life partner, your new significant other to the hearing? Generally speaking, I don't think it's a good thing. If they're going to testify, that's fine, but otherwise I think it's just meant to cause acrimony. I notice those things, so you may want to pay attention to who your client brings with you to the courtroom. All right, Joe Nickrow, 1987, had an Emory board. I think this is like the 4th or 5th pitch in this game. The umpiring crew had actually been watching Nickrow for the preceding year. He would nick the balls and scuff them, and he was a famous knuckleball pitcher, and they went to the mound, and they searched him, and lo and behold, out came from his back pocket came an Emory board. And Nickrow was like, what's that? And the umpire said, well, we've been tracking you. So they kicked him out. He got a suspension. Why do I advise you of this? When your clients come to the courthouse, there is a consent to search. One of the things that the judges are hearing continually at judicial conferences is courthouse and courtroom security. I know that our sheriff's staff does an outstanding job, but as attorneys, I think you have an obligation to the court if you hear something or see something that makes you feel uncomfortable, makes you feel threatened, please advise the sheriffs that are on duty. We have 2 or 3 sheriffs in Mishawaka. You have the sheriffs here. If you see something that makes you feel uncomfortable, you think may be a threat or dangerous, please advise the sheriffs so that they can look into that situation. There have been, we see that a lot of the violence that occurs with judges and with the attorneys in these cases happens at or near the courthouse. So if you ever feel that you're not safe, I would advise you to please contact the court security. They will be happy to assist you to your vehicles. Whatever you need, at least from the folks in Mishawaka, I know that they will take care of you. So that is important to me, that the attorneys and the parties feel safe in the courtroom and the courthouse and the surrounding areas. All right, one of the bad inventions or implementations of baseball is they implemented a pitch clock. I know some may love it. Judge Broden, I don't know what you think of it, but why would you want a baseball game to end quickly? Part of going to the baseball game is you can sit around, you can watch it, or you can lay on your couch and take a nap, and you can wake up and it's still in the 7th inning after a couple hours, and it's not over. So why would you want a pitch clock in baseball? Well, I think it's good. It's bad in baseball, but I think it's good in the courtroom that we have a rule, local rule, that says you need to promptly attend your hearings, and you need to promptly attend your trials. And if something unanticipated comes up, immediately contact opposing counsel or the court staff, in my case, Mary Huzzar, and let us know you're going to be late. If you do that, I'm probably not going to be as irritable as if you're just 20 minutes late and I don't know why. Please, please reach out to the other side as well. I know that at this point in time, most of the attorneys, you bump into each other all the time. You have cell phone numbers. You probably text each other back and forth. I know how this works. So one of the best lessons I got as a young attorney is opposing counsel is oftentimes your best friend. So text them, let them know you're going to be late. They'll tell my court staff as well. So just keep in touch. I've had a few instances where that hasn't happened. I take a very dim view of that. You should show up to court on time. All right, this is an agreement signed by Pete Edward Rose and 1-8 Bartlett Giamatti. This is a 1909 order banning Mr. Rose from baseball. Salient says he just passed away recently, but this was as a result of a 3-year investigation. I think it was a 250-page report, and there was this order, signed order, entered into between MLB and Pete Rose. why do we talk about that? Orders. I think that one of the things that will make these cases more civil is if the attorneys talk about their orders after hearing. I know that there's what, 1 through 15 matters you need to submit orders on. I think you can add 16 would be pretty much anything that you have in front of me. Please send me an order. I think it is a very good practice too, and will increase civility, is I make this statement after the hearing. Attorney X, please prepare the form of order, send it to Attorney Y, and make sure it meets with their approval, then send it to me. I think that one of the things I like in some orders, I see that there's language at the bottom of the last page that says, this order was prepared by X and was reviewed and approved as to form and content by Attorney Y. That way I know that everything's fine. That is a very good practice to have. I like that. One of the other areas I think that you should give me, I'd like to see at least some agreement, is with quadros. I was amazed after I'd been on the bench a while that these qualified domestic relations orders just kind of hop in your queue. And I'm like, am I supposed to sign this? Is this thing they agreed to? I think what I've seen with better practice is you get to get a simple filing if the parties agree to the entry of the quadro. So if you would do that, I'd be most appreciative. Telephone. They're in the bullpen still. Why do I have that? Because this is a local rule that I think that will help all of us out. If I have a matter with you and I'm not ruled in a timely fashion, or I'm coming up on the time that I should rule, it's encouraged and invited that counsel contact the chambers of the assigned judge and remind him or her of the approaching deadline. So this is your chance to call the judge's chambers and say, hey, I'm on like day 28 of this, 29, is Woods going to rule on my motion or not? I guarantee you I will never hold that against you. It was a joke in my law firm that when you call the court staff and you ask about a ruling or an order, you're probably going to get one that you don't want. So we always try to avoid that. I'll never do that. I will tell you that most of the time I try to get my decisions out as promptly as I can. If I sit on one, I'm well aware that in these dissolution matters, sometimes, especially on provisional relief, there's some work that needs to be done to figure out where someone might live or some things like that. So I may not turn that one around in a day or two. I may sit a little longer, but that's by design to let the parties try to work through those issues. Generally at the end of the hearing, if you've been in front of me and it's a matter like that, I'll say, here's what I'm thinking. I'm going to take it under advisement, but I'm feeling pretty strong about this, and that's probably good advice to you to tell your client out in the hallway. The judge has said you may have to move out of the house here pretty soon, so you may want to start looking. All right. Longest game, this is not in major leagues. This is MLB history, was 33 innings between the now defunct, and involved the now defunct Pawtucket Red Sox. So it went 33 innings. I actually looked at the box score yesterday. One player went 0 for 15 with no runs and no RBI. So that would really kill your batting average. It was a 3-2 game. They played it over 3 days. It started as a day game and went into the next night in April. I think it was in May, and then they reset it in June. And it was 1 inning in June, the 33rd inning. And the game was over. Why do I tell you this? Because I know sometimes it feels like it may take a long time to get a hearing date. If you have that problem, I'm going to start this at the start of the year. This is just Woods here. So I think one of the problems I've seen is that I remember coming down to this courtroom when Judge Crone was on the bench, or Judge Manier was, I think, downstairs here in South Bend. And there would be 4 or 5 attorneys lined up. And you, as a young neophyte attorney, I could sit there and watch how the good attorneys did things. I could see Jim Groves go handle an argument. I could see Peter Agostino go up and handle the case. I could see Mr. Blanford, as a young attorney, go up and argue a matter. There is a lot to learn as a young attorney just by observing the more senior attorneys and how they operate in the courtroom. I think litigation via internet has its place. But to have in-court hearings that are being observed by other members of the bar is also important. Along those lines, this rule is from Tippecanoe County, Indiana. They have motion hour from 8 to 9 on certain days. If attorneys have agreements or matters that can be handled rather quickly, and they're just procedural in nature, you can just come down to the courthouse. The first firm I was at had offices in Lafayette and Indianapolis, and it was a big firm. And one of the ways, as a big firm attorney, you got to meet the attorneys in kind of the surrounding firms that Tippecanoe County was just going to motion out. Otherwise, you just never saw them. So this is something at the start of the year, I'm going to probably have Amy put an announcement in the bar newsletter. But if the attorneys, especially in some of in your dissolution matters, if you have an agreement, if you have something that can be resolved in 15 minutes or so, I think on Friday mornings at 8 o'clock, you can just present to my court, let the bailiff know what the matter is. I'll pull it up and look at it real quickly. We'll invite you in. We'll have a hearing, and we can dispatch justice quickly that way. Maybe avoid you some paperwork, get you in court. I'm going to try it. I'm not sure how well it works in today's modern age. It's still a thing in Tippecanoe County, but anything that I can do to invite attorneys to come down to the courthouse in the off chance that other attorneys will observe their proceedings is a very good thing. And plus, it may add to the more efficient administration of justice, and it gets attorneys talking about their files, which aids in civility and also aids in quicker resolution of all these matters. All right, I've exacerbated, I've wasted my time. I'm going to step down, and Mr. Blanford's going to take over from here. But I just want to say it truly is a pleasure to be the judge in Mishawaka and to see you all there. The family law bar, as I said, have so much respect for you all. Thank you so much.
Thank you.
Great. I get to follow that. All right, a couple things right from the get-go. First of all, I apologize for my voice. I don't know why, but about this time every year, I stop being able to talk. Most people find that to be a wonderful thing that they look forward to about this time of year. Nonetheless, I know it's hard to understand, but please bear with me. Secondly, I was really pleased and really thankful to hear Magistrate Wilson tell you that the reason I'm here is because I was a bulldog who found a better way. I was really, really worried that I was Exhibit A, what not to be in courtroom decorum. So the better way, I'll follow that lead and try to talk about the better way as if I was the convert that apparently Magistrate Wilson at least thinks I am. And I am a convert to a better way. I think that a more dignified, less argumentative, or less confrontational approach to the practice of family law is a better way. Now, I understand, there's not a lot of people here I know. There's a lot of, if there were more family law lawyers here today, they'd be smirking, they'd be guffawing, they'd be laughing their asses off, excuse my language, saying, really, seriously, you, up there talking about a more dignified, better way to do family law. Yeah, it's true, but I'm trying anyway. But the thing is that the reason I want to talk about it is because there is, notwithstanding that there is always an appropriate time to go hell-bent for leather, and while there's always an appropriate time to argue your case as vehemently or as vociferously as you need to, there's also plenty more times, an equal amount of times, or perhaps more times, to try to approach it in a less, argumentative way. Why? Well, candidly, I asked that as I was trying to prepare for this today. I mean, I enjoy being argumentative. I enjoy the smart-assed comments in the middle of the hearings sometimes. I enjoy it when there's a back and forth that's witty sometimes, not so nice sometimes. But having said all of that, what I'm trying to keep in mind more and more these days is why that isn't helpful. Two principal things come to mind. One, as a family law lawyer, I deal with principally parents that have children. And I have to remember that what we do in the courtroom with these parents and the example we as their lawyers set can be taken home with them, and that approach can be mimicked, if you will, well, that attitude can be mimicked, and it does not have a good, it does not come out well for the kids. I'll come back to it. The second reason I felt it's a better way to try to be, again, you know, I'm woefully inadequate at doing it as often as I'd like to, but another reason to try to be less confrontational is because of the toll it takes on us as the lawyers, perhaps the judges as well. They don't want to hear this stuff any more than, they don't want to hear the bickering. They don't want to hear the back and forth. And so it does take a toll on them as well. But the toll it takes on us as the lawyers. And again, in preparation a little bit for today's discussion, I tried looking at some statistics. I looked at the American Bar Association studies that have talked about lawyers and how confrontation and how conflict and how the regular diet of confrontation and argument and conflict can have an impact on the lawyer and his or her health. And the simple fact is, and you've all seen this, if you've not read the actual reports, you've heard anecdotal evidence of what it does. We all know that lawyers as a whole, family law lawyers in particular, have increased rates of suicide. We know that they have increased rates of depression. We know that they have increased rates of substance abuse. And why? Well, okay, man, some of us might just be prone to it, but it also is because I believe, and some of the studies would suggest, that the conflict begins to wear. The conflict begins to tear at you and undermine, well, one thing for sure, your life-work balance, which then leads into more work, which leads into more of the issues that we are talking about and the confrontation, the problems of the confrontation, the conflict, and that kind of work will cause you. It's almost a never-ending cycle. So I may be repeating myself, never-ending cycle, but the fact of the matter is that it is hard work being an asshole all the time. Excuse my language. It is hard work trying to fight with the other side or fighting with the other side all the time. Again, please don't misunderstand. You have to fight sometimes. There are causes you have to fight for sometimes. There are positions that you have to take on behalf of your clients. Sometimes that may sound mean-spirited, it may sound accusatorial, if that's the right way of putting it. Sometimes you have to do that because it's what the case is about. But sometimes you don't. I was in court just 3 or 4 days ago in a rather heated, rather important case, we'll say. I made a comment in the course of my argument that I immediately regretted. Believe it or not, I immediately regretted it. Go figure. That comment was, it was a little bit below the belt. It didn't need to be made. It didn't accomplish anything. It didn't get me any closer to what I wanted to get to at the end. But there was an opportunity that presented myself, and I made the comment, and I thought to myself, what the hell? I didn't need to do that. Changing out of your parents. I talked a moment ago about how our attitudes, how we present ourselves, how we argue our cases, how we approach the other side impacts the clients, the parents. Again, whether you've seen the actual studies or not, you know this is true. If you've been in Mishawaka, and I think it's Magistrate Gamage's courtroom, there's a sign that says, right on the bench, it says something about the nature of, how, and as I stand here talking, I don't even remember the actual quote itself, but how well kids do.
Best indicator of a child's later maladjustment is something with how the parents have
conflict between parents.
Yeah. And if we are not helping avoid the conflict, we are helping the conflict. And the simple fact is, our clients will take that home. They will, if they see their lawyer arguing that dad is the bad guy, they're going to take that home. Mom might take that home. Somehow it's going to get mentioned to the children. Mom is going to suggest by her act, Mom or Dad, you get where I'm going with that. A parent is going to take it home. A parent is going to laugh with the neighbor while the child is standing next to him about how his or her lawyer called Dad, this, that, and the other thing. And it is going to get to the whether the kid's standing there right next to you or not, it's going to get somehow to the kids, and they're going to pick up on it. And it's not going to go, it is not going to move their relationship with their children in the direction that we want it to be going. Now, so what I thought I would do when I was preparing for this, I thought, well, okay, fine, that's great. We can stand here and talk about what we need to do to reduce the conflict. We can say we need to reduce the conflict. Well, that's great. Well, if you don't know how to reduce the conflict, well, if you don't take some concrete step towards reducing the conflict, then you're not reducing the conflict. You're talking about it. You're not doing anything except blabbing your lips about it. So what can you do? Well, okay, so occasionally, let me back up. I think that it's not a bad idea to come up with ways to approach things, the way to approach your case in court that consciously is an effort to keep the tension down as much as possible. What's one way of doing it? Again, this is for both the lawyer and the clients. As you come into the courthouse with your client, maybe for the first time, your client, you've never met your client's opposing party, your client's spouse, we'll say. Approach that person. Not with, knives coming out of you. Approach that person. Hi, my name's Greg Blanford. I'll be representing your wife today. Not in a smart-ass way, not in a mean-spirited way, not a I'm going to stick it up your nose, buddy way. You're approaching that person just in the hope of trying to convey to him that, look, you're not the person that maybe you've been, that you've heard, that you, the client, has heard. It's not a bad idea that when you're standing in court or when you're waiting to get into the courtroom, you see your opposing counsel come in with his client. When your client says to you, "Oh, is that my husband's blah 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 bad language lawyer?" Maybe instead of saying, "Yeah, he's a jackass," or "Yeah, you're right, he's this or he's that or she's that or this, she's this," maybe try to minimize that. Maybe try to change the direction of that. Maybe that lawyer is a complete difficult person. But if you're encouraging that lawyer, that disrespect, we'll say, I think it undermines your own position, the respect you need to have from your client and from others because, well, that's how children talk. He's a butthead. Yeah, he's a butthead. Yeah, I agree, he's a butthead. No, maybe you ought to say, yeah, he's a tough lawyer. She's a tough lawyer. She'll do a good job. She's tough. I know there's some things that he says or she says can be, hard. And she can sound mean, but she's a real good lawyer. A couple reasons why you want to do that. Frankly, you want to do it from a self-preservation standpoint. You start acknowledging that he's a really some jackass, and then he wipes your floor with your nose in court. Well, maybe you haven't done yourself any favors. Some jackass just wipes your nose and wipe the floor with your nose. I mean, you don't want your client thinking that he's such a bad lawyer, she's such a bad lawyer, only to have that bad lawyer come and show you who's boss. That's, if nothing else, it's to your own benefit. In court, in the courtroom, avoid the tendency, if you can. I've found it more difficult, more often than not, to avoid this tendency, but try to avoid the smart alecky comments. Try to avoid the mean-spirited, nasty responses that aren't going to get you anything except perhaps a chuckle from your own client, which doesn't do you any good. Try to avoid points that are only made for mocking or belittling or demeaning other counsel. And unfortunately, we like to think that doesn't happen, but it does. You don't need to in an argument to the judge, Judge, maybe Mr. Blanford doesn't know the law in that manner. Doesn't help. It ticks off Mr. Blanford or whomever. Mr. Blanford may not have known the law, but it doesn't help anybody to tell the court that. It just makes things more difficult. It makes things more angry. It makes things more likely to result in argument. Bear with me while I look at my notes. I think it's important to recognize, it's important to build the connections between yourself and other counsel. I think it's important because I think our clients need to hear and see that, yeah, we will represent your interests well, we'll represent your interests vigorously, but I'm not going to destroy my relationship with other counsel if I don't have to. I'm not going to, I'm not going to beat that other lawyer up for no reason. Again, God, I'm almost biting my tongue when I say those things, because it's been for a long time that I've done those things. But when you hear a lawyer make a good argument, your opposing party, opposing counsel, make a good argument, or do a good direct, or good cross-examination. You don't have to say it in the middle of court, but maybe on the way out. I know this sounds maybe a little bit weird, but stop the lawyer. Say, Joan, that was a good direct examination. It's hard to get real ticked off with, don't get me wrong, you can be ticked off and you can be angry and you can still represent your clients, but it doesn't hurt to acknowledge for that other lawyer that, man, that wasn't bad. It doesn't detract from your own abilities, your own presentation, but it serves a purpose to let that other lawyer know that, man, yeah, I wasn't bad. That lawyer might say, thanks, appreciate it. That happened to me not too long ago. Someone said that to me about a cross-examination. I thought he was full of crap. I didn't know if he was being drunk. I thought maybe he was just pulling my chain. But then I got to think about it, it wasn't too bad. And then I appreciated that comment that, he made, that it was a good cross-examination. Thanks. Now, again, is that going to make me represent my clients any less vigorously? No. But I will remember that comment, as I am now. It doesn't hurt to keep in mind that we as lawyers, we're people. And we go through our own sets of circumstances that sometimes makes our representation of our clients difficult. And I bring that up because, if you know, for example, of a lawyer, a peer of yours, that might be going through something, you learn from it from that person or from somebody else. And if it impacts that lawyer's ability to do, some simple things that you might be able to do, it doesn't hurt to, if you see that lawyer, to say, hey, John, I heard that you're going through this. I want you to know if you need someone to stand in for a short hearing, a scheduling hearing, or a continuance. You're not going to stand in for an evidentiary hearing, clearly, but you're passing on to that lawyer, look, if you need me to stand in for you and just get something minor done for you, I'd be happy to do that. Again, I think it takes away from the fight. It takes the fight away a little bit. Some of these things might be helpful, some of these things might not. The biggest thing is, though, I think that we need to approach our cases with a recognition that what we do in court with our clients and to other clients is something that impacts all of us long term. Your mental health and your own well-being included. Thanks.
Okay, it's not my strong suit, you all know that. So it's a real privilege for me to preside this time in the beautiful courtroom across the rotunda. Kind of mirror image of this courtroom. And sitting in this courtroom, I see Judges Montgomery, Crone, and Dodge, and I think, I practiced before 2 of these judges and served with 1 of these judges. And they're all retired, and yet here I still am. So for reasons that you may discern as I go through my little presentation, I thought perhaps I should have come today in one of those inflatable T-Rex costumes. Because I'm a bit of a dinosaur, and this reminds me in another way that I'm a bit of a dinosaur. So I'm going to be speaking about Odyssey generally, not the famous one, but the one we're stuck with. Odyssey, our local rules, and some personal practice preferences of mine and my staff. And it is not as organized as Mr. Blanford's or Judge Wood's presentations, but it is what it is. And so why have I chosen this topic? I was coming to work a while ago. I'm driving west on Washington, stopped at the intersection with Main Street, and it's dark, not real dark. I was not coming to work at 4 in the morning, but it was still dark. And I looked up, which I don't always do, and there's the cupola of the 1855 courthouse poking out from the side of the dome of this courthouse, the 1896 courthouse, and the tower building, which is uplit and beautiful. And I'm looking at this image, and I know that the jail, the old jail, which is now also a courthouse, is tucked in there too. And I thought, well, this is really impressive. It's like a physical manifestation of the operation of the justice system that we all participate in. Courthouses, jails, lawyers' offices, people within and among and between those buildings in the enterprise of working out, or in the business of working out an enterprise that works itself out in the lives of individual human beings. And it's been like that since its conception in this country. And it still is, except it's different, because we now have, as we have always, but this somehow to me seems like a different movement, the introduction of technology into the legal system. So as a kind of a bookend to the edifice image, I'm sure we've all been in the basement of the courthouse relatively recently, and there's no one there. Remember, you'd come in with your little complaint and you clock it in that machine and you get your docket sheets, and now there's just no one there. I know these clerks are different places. They are still working, and they're displaced, but something about that community of lawyers and clerks and clients is just, I feel like it's missing. And some of that has to do with the advent of technology. Filing is now electronic. I think there's probably people in this courtroom who have never filed anyway but with Odyssey. Wow. That is, that's good, right? But it's different. And I think there are things that are remnants of the enterprise that was more personal, that it's a shame to have lost, so whatever. Anyway, so I thought, okay, I know what I'll do for my presentation. I'll think about what local rules we have or practices we have that support a more interpersonal relationship among attorneys, with the clerks and the judiciary as appropriate. And so I thought that was a great idea. And it turns out it's not really a great idea. Because I'm going to go through my presentation, but it didn't work out quite as well as I thought it would. So let me then start, though, with Odyssey. Everybody's familiar with Odyssey, I'm sure, by now. Filing, again, there's some people here who have only filed through Odyssey, have no memory of a personal trip to the courthouse, getting your docket sheet, chatting with whoever, seeing who's running for whatever office in the big chalkboard down there. Now you're in your office, and I don't even know how you file through Odyssey, I have to be honest. And I'm sure there are, I believe there's multiple providers, I guess, that you can use because the filings come in differently on my end. It's electronic, it's immediate, but there's a common misconception about how immediate it is between lawyer's office and judge's chambers. So often, one of the best things the judge likes to hear is so-and-so called, they're canceling the hearing tomorrow because they reached an agreement. Well, now that you can file at 2 in the morning, we get a lot of filings on the morning of the hearing, motion to continue, motion to vacate, and there are so many layers of gatekeeping between you and me that we're sitting around, well, where's Mr. So-and-so or where's Ms. So-and-so? So I would suggest that if you do have a last minute continuance request or vacating, you want to vacate something, that you call in the morning. I know my staff, and I'm sure everybody else's staff, all the other judges' offices, like to get those calls, like to say hello, keep that interpersonal relationship alive. But it's important, it's helpful to us that you do that. Same thing with an email, but a call is nice, right? Because it's you calling with good news. It's never bad news that you're continuing something. In a like manner, when cases get continued or there's a hearing that needs to be set and there's multiple parties, it's the practice of my office. We don't just set a date. My secretary Janice sends out an email. Here's some dates. Let me know which ones you're available for. And that's helpful. Usually we can get a hearing reset in that fashion. But it's incumbent upon the attorneys to respond. And it's kind of surprising that we can go days without a response. And by the time the last response comes in, the other people's preferred dates have now been taken up. So at least with respect to my office, if you find yourself in a situation where we're scheduling in that fashion, it's real helpful if you can respond. And if your response is none of those days, that's a response. Just keep us advised. In terms of Odyssey filings, if you can, I don't know what you do, but if you can identify your document as specifically as possible, sometimes I get in my queue, motion, 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 one filing, or motion, order, order, order. And things that you wouldn't think about, for example, if I sign an order in Odyssey, let's say order, 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 and then I thought, oh, did they submit a notice of debtor's rights? And it's not separately filed, and I go look on the order to see if it was attached to any of the orders. Anytime I open an order that I signed in Odyssey before I moved it out of my queue, the signature disappears. So, and then keeping track of which of the orders you've signed, because they all look the same. So if you can identify, for example, garnishment order or bank interrogatory or whatever, it's just real helpful. And I don't know how, to be honest, I don't know how you name those documents. I don't mean the caption or the title of the document itself, but the identifier that travels it with it through the Odyssey case management system. The more specific, the more helpful. And I noticed we have a local rule 201.3.4. All pleadings or motions shall include a title, which shall delineate each topic included in the pleading. For example, where a pleading contains an answer or motion to dismiss and a jury request, each topic shall be set forth in the title. Well, you all do that, but if you could, again, translate that also into the identification of those documents, in Odyssey, that's helpful. Another thing on Odyssey that's frustrating is we have stamps. I missed the chance to use that seal. I missed the stamp where you change the date. We have little things, icons. The date stamp, folks, I'm asking you to either put dated or date, colon, and a line, but not to put on your documents dated this blank date of blank, 2000 blank. Because each of those blanks you cannot do that in one fell swoop. Each is a separate, hit the icon, type it in, it takes a lot more time than you would imagine. Or for a while I was just taking the date stamp and putting it on the place where the month was because it fit there. But I like things to look like they should, and that looks stupid. And if you erase, we have a little erasing function on Odyssey that sometimes you can't cover over that, can you? And I don't understand why you can sometimes and why you can't sometimes. So just put dated, and in fact, we have local rule 213.2, proposed forms of order. The last page of the proposed order shall contain a line for the date, either dated blank or signed on the date file marked hereon. So it's actually a local rule that you do so, and it's really quite helpful. Here's a big one, a big request from me. Motions for summary judgment. Just consider providing the court with a hard paper copy of your designated evidence. It's really, I find it very time-consuming and difficult to go through the electronic versions. Now they're good. I learned you can search, which that's helpful. But I end up printing them out. So maybe I'm just looking to shift the burden to you or the expense from the taxpayer to the courts. But it is helpful and just something to consider. Another one that we've all seen, I think, on our court this happening. The St. Joseph Superior Court is a unified court. We are one court with 8 judges who are appointed and retained. We all know that. But we are not, my case designator is DO5, my court designator. I'm not St. Joseph Superior Court number 5. And most courts in all other counties are Superior Court 1, 2, 3. We aren't. We're just the St. Joseph Superior Court. And again, we have a local rule on that says that exactly. Do not refer to any of us as St. Joseph Superior Court number 1, 2, number 3. We're just the St. Joseph Superior Court. And somewhat in that same vein, special judges. If a case is transferred from the Superior Court to Judge Broden's court, he is now a special judge of the St. Joseph Superior Court. If the case is transferred from Judge Woods to me, I'm not a special judge. We're one court. If a case is transferred from me to Judge Broden, and then someone else takes a change of judge, and it comes to Judge Woods, he's not a special judge. Judge Broden was, so within our court, we're not special judges of our court. So just a little reminder or info. Okay. Local rules. Motions to withdraw. If you have written consent in open court, or someone has entered an appearance before yours is withdrawn, and if your motion contains appropriate contact information concerning your client, the court will pretty much summarily approve your request without hearing. However, if you don't have consent, you must file a motion, obviously, and set it for hearing not fewer than 14 days from the date of filing. Not fewer than. So you can't get out tomorrow because you got a hearing on Friday. You're supposed to file, and if the case has been set for trial, you're supposed to file your motion at least 30 days prior to the trial date, unless the court gives you permission to file it sooner or closer to the date of the trial. It's amazing how many motions we get that say irreconcilable differences with my client. Doesn't say, or my client consents without the consent being attached, and without a notice of proposed form of order being filed. the notice, the service, if you don't have consent and you are required to serve notice to your client. And that notice by local rule is to be by certified mail. That rarely happens. To the client's last known mailing address. And the council must present the court with, quote, adequate proof of notice of intent to withdraw and of impending trial, pretrial, or hearing dates to the client. This is Rule 204.2. The rule is requires more of you than you might imagine. And in terms of consent, it's perfectly appropriate for me, an email, a redacted letter, whatever, a signature from your client. But, you know, a simple motion to withdraw irreconcilable differences, or that's not a phrase, that's a, I can't think of the phrase.
Irretrievable breakdown.
Yes, there we go, right.
Or substantial breakdown, whatever.
Yes, right. It's not adequate, really, without notice or consent.
And if I can just chime in on that rule for 1 second, Your Honor, with your permission. The reason that there are these hoops to jump through is not to be making you do busy work, it's to protect you from that client who then files a complaint at the disciplinary commission that you abandoned the client and didn't tell them. That's why we want that hearing and proof that they knew, so that you got some cover.
Indeed. And yeah, it's a tricky, so for example, letters to clients are usually highly redacted, but what's not redacted is I'm planning to withdraw. We don't want to see that information, obviously, between you and your client, but something that shows that you've given them the appropriate notice. Discovery disputes. First of all, discovery is not to be filed with the court. Everybody knows that. It still happens. You're not to file your discovery with the court unless it's in connection with a discovery dispute. And alas, we have no local rule, prohibiting the filing of discovery disputes, which are one of the things that most of us as judges hate, because we get dropped into the middle of your case without any context at all. And it's usually a big fight. But we do have a rule that travels or parallels the trial rule that requires counsel to attempt in good faith to resolve all disagreements between or among themselves concerning the necessity for scope of discovery, necessity for seeking sanctions and or protection against discovery. This is Rule 208.5. And a motion to compel discovery responses may be filed only after personal consultation and good faith attempts to resolve. So, what is personal consultation in this modern era? Is it a series of emails that don't get responded to? Is it a voicemail? Is it a letter? If so, any of these things, how many? I believe personal consultation includes or requires you to use your voice, speaking into the ear, either directly or via a device of another person. Not a voicemail, not an email, not a letter, but a call. Hey, Attorney X, I noticed I haven't received your responses from my discovery. If you need a little extra time, that's fine, but the whole point of that rule is that it's kind of like Mr. Blanford's comments about snarky remarks. You know, I've seen a lot of snarky emails about discovery responses not having been provided, and for some of us, it's easier to be snarky in writing than in person, right? And it's a good way to, I think things get resolved more when you speak to other people. And not always, I understand that. But it maintains this enterprise as a human enterprise, and that there's a way of treating other people, which includes recognizing their humanity and speaking to them as a professional. So,
Can I say something?
yes, you may.
I agree 100% with Judge Manier. I can think on a couple of occasions that attorneys have not spoken to each other on the phone or across a conference room table, and I'm not taking up your discovery dispute. The attorneys aren't invested enough to pick up the phone and have a conversation or to sit down and try to resolve the issue. I'm not taking up a discovery dispute. So that's the way it works. As well, sometimes some of these discovery disputes deal with such nuanced issues about business valuation and complex commercial matters. I think it's impractical for a trial judge to try to wade into those issues because they're so complex, and even the best of attorneys can't get everything in front of us. I've required parties to mediate those types of disputes. You're going to go to a mediator to sit down and try to resolve it. So those.
That's a good idea. Yeah, the discovery disputes are awful. I mean, you've been working in the trenches on this case, and you know, frankly, you file your complaint. We don't see the complaints. That doesn't come to us. We don't usually see the answers. You know, I get a list every week of the new cases filed in my court. But, so I know what's been filed by name and what kinds of case it is. But until something files that needs my attention, a motion is filed, a motion, or it comes up on our calendar to set it for pre-trial, to set a trial date, you know, we're not in the weeds in these cases. And even if you know read the complaint and the answer, that's, by the time you're getting into these complex discovery disputes where they're so complex and people are intransigent as to whether this is a reasonable response or not, it's, you know, we're walking in blind. So I don't know that counsel actually know that or are aware of that, but none of us like those because we feel very incompetent, I think, to resolve these. I do. I always,
May
I
chime
feel
in?
incompetent.
Well, one other thing, I don't know that it's a matter of incompetence, Judge, but you know, the other thing, don't forget that both Trial Rule 26F, you can't look at just 37, you got to look at 26F. And our local rules say that after you've had your personal consultation, which I agree is in person or over the phone, you've got to recite in your motion to compel when you did it, whether it was in person, whether it was over the phone, who participated. That's why I strongly believe that it is actually a one-to-one personal discussion and not just, you know, this is my effort, this email is my effort to resolve this before I file a motion to compel. I don't care. Sorry. I have issued orders denying motions to compel, saying do it right and I'll consider it. The other thing I'll do is if you didn't do it right the first time, you're not getting fees. Even if I grant it, you're not getting fees.
Right, and fees in my, I don't know if everybody has the same reading of the trial rules as I do, but motion to compel with a form of order that says they were due January, you know, it's now March or June. I made this effort, that effort, and the other effort to get responses. I'll sign a motion to compel, but I will not order fees unless it's an order to compel, rather, unless there's a hearing because the order to compel is not being complied with. You know, there's an initial motion and an order. Gives the discoveries between the parties. We don't get involved until there's a motion to compel. Okay, now there's an order, not just a rule, an obligation to follow the rules. The order to compel say, you know, you need to respond within 15 days of the date of this order or whatever. And if that doesn't happen, I get notified of that. Then it gets set for hearing, and then fees attached. And it's an obligation. It's not. It's mandatory at that point, not discretionary. And yes, Judge Wilson, if before contacting it, yes, you do have. It is. You're out. Here goes the chicken. Printing shall be on one side of the paper. Margins shall be at least 1 inch. If typewritten, the lines shall be double-spaced except for quotations, which shall be indented and single-spaced. Typefaces shall be 12 font size or larger within the body of the document and 10 font size or larger in footnotes. The font type must be legible, and script type shall not be used. Italicized type may be used for quotations, references, or case situations. So, here's an example of a fleeting, single-spaced, at least 1 inch, so big margins, single-spaced, different fonts. Of course we do. We know this. You know, it's an effort to be different, I guess, but it's not compliant with the rule. Here's another one, and it's hard to see, but there's italicized at the top in the St. Joseph Blanford, so I think it's an effort to, it's like an honorific, right? We're italicizing the court name. But that's not compliant with the local rule. And this font not only is this single spaced, the font size is small. It's smaller than 12. It may be smaller than 10. This is not yours.
I know.
Mr. Blanford is probably got the smallest font.
8.5.
On the other hand, this is Appendix D to the St. Joseph Superior Court rules, or the St. Joseph County rules. This is the worst thing. This is the notice of debtor's rights. And there's nothing wrong with printing the notice of debtor's rights on one page, but this god-awful document has on the top of it an order in, I don't know, 8, order to appear. Look at that. That is such a tacky document that we must redo our rules and fix this. I mean, I see very few of these. They're generally from out of county. Most people, thank you, create the notice of debtor's rights as a separate document and file it as a separate document, or you'll attach it to one of the orders in a pro-sup filing. But don't use this document as a template where you have an order to appear and the notice of debtor's rights all on one page. It's not compliant with the rule, and even though it's in our rules, and it's just not professional, frankly. There is a requirement that I don't know where it is, that you file a separate rule and motion on anything. You can't make your order a part of your motion. As in small claims, there's a lot of combination. Odyssey requires, and if you do that, the administrative staff have to rescan in everything twice and designate one as the order, one as the motion. So that's important. Looks like we're at the end. So.
Great stuff.
Okay. Thank you.
Thank you. You will all be glad to know this brings us to the end of the day. Your weekend has begun. Thank you all very much, and you know, to spread the word that when we do this sort of thing again, that it's worthwhile.
And we have recorded it, so if there's any parts you think people in your office would benefit from, it will be available. Hopefully, I hear the sound like okay. You all have this sheet. If anybody needs one, but otherwise you can hear credit. Thank you.
Take care. The maximum points.
Amy, thank you.
Thank you, I thought you did an excellent job.
You report my hours for speaking credit.
I saw